Pedersen v. Office of Personnel Management. Pedersen v. Office of Personnel Management is a federal lawsuit challenge. The district court that originally heard the case ruled Section 3 unconstitutional. On June 26, 2013, the Supreme Court of the United States ruled Section 3 of DOMA unconstitutional and denied appeal of Pedersen the next day. Legal proceedings. Gay and lesbian advocates and defenders GLAD filed the case in U.S. District Court on behalf of 6 same-sex couples and 1 widower in Connecticut, Vermont, and New Hampshire, making the same arguments it made in Gill v. Office of Personnel Management, that Section 3 of the Defense of Marriage Act should be found unconstitutional based on the Fifth Amendment, equal protection. It prevents the federal government from recognizing the marriages of same-sex couples who are legally married in their own states or other jurisdictions and restricts the federal government from granting such couples benefits. On February 23, 2011, Attorney General Eric Holder released a memo regarding 2 lawsuits challenging DOMA Section 3, Pedersen v. OPM and Windsor v. United States, stating, after careful consideration, including a review of my recommendation, the President has concluded that given a number of factors, including however, the administration also announced it intended to continue enforcing the law until its repeal by Congress or until ruled unconstitutional in court. On April 18, 2011, leaders of the House of Representatives announced they had chosen former United States Solicitor General Paul Clement. On July 15, the plaintiffs filed a motion for summary judgment. On June 20, 2012, BLAG asked that the case be put on hold pending Supreme Court action on the First Circuit decision in Massachusetts v. United States Department of Health and Human Services and Gill v. Office of Personnel Management, which BLAG was appealing. The court denied the request on July 4, 2012. On July 31, Judge Vanessa L. Bryant found for the plaintiffs. She wrote, having considered the purported rational basis proffered by both BLAG and Congress and concluded that such objectives bear no rational relationship to Section 3 of DOMA as a legislative scheme, the court finds that no conceivable rational basis exists for the provision. Appeals. The DOJ appealed the decision to the Second Circuit Court of Appeals on August 17, 2012, and Pedersen filed a petition for certiorari before judgment with the Supreme Court on August 21. On September 11, the Solicitor General filed a similar petition urging the Supreme Court. The Supreme Court denied these petitions on June 27, 2013, following its decision in Windsor. Plaintiffs. Joanne Pedersen and Ann Mateson of Connecticut. Joanne is a retired civilian employee of the Department of the Navy and recently retired from work at a service agency for the elderly and disabled due to a chronic lung ailment. Joanne cannot put on her federal employee health insurance plan because of DOMA, which would save them a significant amount of monthly income. Geraldine and Susan Artis of Connecticut. Geraldine, who is studying for a degree in counseling, and Susan, a school librarian, have been together for 18 years. They have 3 sons, a teenager and twin 12-year-olds. Because they cannot file their federal tax returns jointly, they have paid thousands of dollars extra in taxes since they got married in 2009. Jerry Passero Roman II of Connecticut. Jerry lost his spouse, Thomas Buckhalls, to cancer after more than 13 years together. Jerry, who is disabled and lives on a modest income, was denied Tom's pension and a Social Security death benefit because of DOMA. Dab and Jerry Savoy and John Wace of Connecticut. Jerry is a federal employee with more than 20 years of service, and John left his job as an interior designer to be a stay-at-home parent for their 3 children. Because of DOMA, Jerry can't cover John on his federal employee health insurance plans, so they pay an extra $450.0 per month out of pocket for John's health insurance. James Flint Jayer and Bradley Kleinerman of Connecticut. Brad and Flint have been together for more than 20 years. The parents of 3 boys, They relocated from California to Connecticut to give their kids a better quality of life. But because they cannot file their tax returns jointly, they have paid thousands of dollars more in taxes over the course of their 3-year marriage. Janet Giller and Joan Marquis of New Hampshire. Jan and Joe are retired teachers who have been together since 1979. They both receive pensions through the New Hampshire retirement system. Because Joan had more than 30 years of public school service, she is qualified for a health insurance benefit for herself and her spouse. But she was denied the spousal benefit for Jan because of DOMA, which means they pay more for Jan's health care coverage. Raquel Arden and Linda DeForge of Vermont. Raquel and Linda are military veterans who have been together since 1977. They worked together for many years at the U.S. Postal Service. Raquel suffers from degenerative arthritis in her neck and requires quarterly medical treatments at a VA hospital in Connecticut. Linda was denied Family Medical Leave Act time off to accompany Raquel to her appointments.